All right, welcome back. The news continues on News Hour. I'm speaking to LSK President next, Eric Theory. Before I do that, let's go through some of the cases that have been filed against President William Ruto since he was elected. So we begin with the first case as president-elect, Raila Odinga versus William Ruto and others. That was the first major case, August last year, 2022. But then subsequently, there has been several other cases against his administration. For example, there were a lot of petitions around President Ruto's cabinet appointees. They went to parliament and they were challenging the suitability of his appointees at that time to sit in the cabinet. So those were a lot of petition, and eventually they were all taken in as cabinet secretaries. But apart from that, there is this specific one that has now been declared unconstitutional, the appointment of the chief administrative secretaries. And in this case, the parties were LSK, Katiba Institute, activist Eliud Matinda, and of course, Multitouch International. Now, this case has been since adjudicated, and these positions, all the 50 have been declared unconstitutional. Apart from that, there was the case against the Finance Act. But before I look at that, let's take a look at the case against the Finance Bill 2023. It was taken to court by Okia Omtata versus the CS Treasury. But you remember, it was a little bit preemptive because at that time, it had not been passed in Parliament. It had not been assented to. But all the same, Okia Omtata took this to court. And eventually, we go back to the Finance Act 2023 because this case was in court and its current status, it's been pushed to next week on Monday when a ruling whether it should be lifted or not will be given. But the Finance Act 2023 is also a case against President William Ruto's government, and I've talked about the bill. But let's look at another one, because there's one, strangers in the cabinet. This case has been forwarded to court by lawyer Charles Mugane. LSK, we're learning now that LSK has actually also filed a case against the strangers in the cabinet of President William Ruto. They are questioning the manner in which the four were nominated, including Malala, who is the Secretary General of UDA, and three other advisors, including one of LSK's own, who's inside there, Harriet Chigai, is also inside there, Dr. Devin D, and the rest. So basically, these are the cases that have faced President William Ruto since he was elected to the national government as president in August 2022. But let's break this down now by speaking to the LSK president, who is here with us now, Eric Theory. Asante sana, Mr. President, for coming tonight.
Thank you, Ken.
So many cases against the President William Ruto's government, but I want to start with the latest case. Now, the latest case is on the strangers, what we call the strangers in cabinet. You tell me that LSK has already filed a case?
Yes, we did file a case challenging the case of the strangers, as you're calling them, in the cabinet. As you are aware, this is a matter that has previously been determined by the courts, and the courts were very clear that the composition of cabinet is set out in Article 152, and that the procedure for appointment for any person to sit in cabinet has been set out in the Constitution, and they have to undergo vetting, and so therefore the president has no power whatsoever to appoint anyone to sit in cabinet or to designate anyone to sit in cabinet other than as per the procedure provided for in the Constitution, and the numbers are actually also expressly limited in the Constitution.
The argument is they have not been designated as cabinet secretaries. What has happened is the president, they were sworn in. They took oath of secrecy to sit in the cabinet as advisors, not as cabinet secretaries. So the oath we saw that day was actually oath of secrecy, not an oath to be a member of the cabinet.
Essentially, I think it's a question of splitting of hairs, because the cabinet is composed of cabinet secretaries. You sit in cabinet by virtue of your appointment as a cabinet secretary. So anyone who sits in cabinet cannot sit in any other capacity other than as a cabinet secretary. Yes. So then the question then becomes, when they sit in cabinet, who do they sit as? If they are advisors, and what happens in any ordinary meeting is that if there is a need for an advisor or if there is a need for an expert, the expert can be called in to shed light on his area of expertise and thereafter leave and allow the cabinet members to then deliberate on the expert information that they have received.
Okay.
Yes, and the fact that they are even unable to explain how they are sitting in cabinet is actually where the problem is.
Okay.
And this is exactly what Alice Wahome, now CS, challenged.
Had gone to court for.
Yes,
exactly.
And the court was very, very unequivocal in that this cannot be allowed to happen.
Okay, so Article 152 that you've alluded to says the President, the Deputy President, the Attorney General are not fewer than 14, but not more than 22 cabinet secretaries. There is no argument, Wakili, that can fly in this. There is no way you can see the law, you can circumvent the law to have them in cabinet, even as advisors. Probably the next cabinet they'll be sitting on Tuesday or on Thursday, they will not be present. There's no law.
There's nothing that can expand that composition.
Executive orders?
They cannot.
Supersede the Constitution?
Nothing can supersede the Constitution.
Okay.
Yes.
So
that, in fact, Article, I think, 3.2 is very specific, that an attempt to constitute government other than as decreed by the Constitution is in itself unconstitutional.
Okay.
Yes.
Okay. Let's get because that now is in court, and I know you're going to court. You've gone to court on that. But let's talk about the CAS positions. You are interested parties in this. It's been declared unconstitutional. Can they appeal this decision?
Yes. They have a right to appeal the decision.
On what point? Because this was a constitutional court. On what ground, on what point? And fairness, what would be the ground?
Well, I want to imagine that they'll probably be challenging the declaration by the court that the position is unconstitutional. So we still are waiting to see what grounds they will be approaching the court to challenge that decision.
As an officer of the court, there's precedence on this. President Uhuru Kenyatta appointed CASs. Define the difference between what Uhuru Kenyatta did and what William Ruto is doing.
I mean, there's the courts then and the courts now have found that position to have been unconstitutional. The only difference is that in which may actually appear to be a difference, is that at the time the cabinet secretaries were declared unconstitutional during the former president's regime. They were already in office.
Okay.
They were already in office, and so the court, to avoid, and that is what it said, to avoid disrupting the business of government and all those things, sort of created some sort of, and then there was COVID at that particular time, so the court did some sort of stay of the declaration of invalidity. In this particular instance, they have never discharged the functions of that office. And so the factual matrix is completely different as at that particular time. But what is common in both instances is that the courts have found that office to be unconstitutional.
Would it have mattered if there were equal numbers, 22, 22? Would it have changed the metrics, as you said?
It wouldn't have, because the issue here is that there is a guideline judgment that was issued by Judge Murima. And one of the findings which Judge Murima arrived at, which this court, the subsequent three bench has also upheld, is that this position enjoys the stature of a state office. Because it is a position that is lying in between the CS and a PS, which are state offices, and therefore, for purposes of enjoying constitutional legitimacy and considering the impact that they have in terms of dictating policy, in terms of dictating, in terms of spending public money, in terms of making decisions that are binding on the citizens, not just the current citizens, but also impacting future generations, that there ought to be an element of vetting.
Okay.
Yeah, vetting for purposes of gaining acceptance and supremacy through the process of parliamentary approval. And so that was never complied with. And if you remember, the intention of the presidency when they requested Public Service Commission to set up the office was that the nominees would then be taken to Parliament.
Did Parliament set them up to fail?
For purposes of vetting. Parliament just did the right thing.
Yeah, by saying
there is no legislation that requires them to vet.
Okay.
And that is the biggest issue here, that you needed to have had the national legislation that underpins that position, creates it as a state office for purposes of vetting and in compliance with the decision in Murima.
What would happen if they sit aside and obviously they create, because I believe this is not one of those articles that need, that will require, for example, a referendum to change that composition unless it is before I even proceed. Does it?
Yes, it would, because it will be in a view depending on
changing the
where
form of
they
the
place
government.
it, changing the form of government.
Okay.
Because if then it is, you remember the basic doctrine structure. If you are then expanding the composition of cabinet, then those are questions that will have to...
No legislation that can come forward, the AG cannot draft, take it to cabinet to create this position from where you sit.
Well, I'm not saying that, but whatever the courts have said, that you need to create legislation to establish this office.
Okay.
Of course, once that legislation is done, then the next question would be, how or where does it sit within the current constitutional architecture? Remembering that one of the reasons why the court has also found this position to be unconstitutional is that in the interpretation of the Constitution, one has to take into account the historical perspectives that led to the enactment of a particular article in the Constitution. So what is the historical perspective of limiting the number of cabinet secretaries to 22 and the very, very clear voice from Kenyans that they do not want a bloated executive, that they do not want assistant ministers. So as you create that office, that then is the test that you must answer. Are you recreating the position of assistant ministers, which Kenyans, who are the supreme when it comes to the question of how they ought to be governed, have determined that they do not require that position.
Okay, I have a few minutes on the clock, but I need to ask you this. The Finance Act 2023 has been suspended and it's been extended until next week on Monday. However, we saw EPRA completely, well, it happened before they went to court and it was suspended. So ordinarily you will expect they will walk back on that. But they didn't. And EPRA is implementing the Finance Bill 2023. What happens? I mean, they're just doing it.
It's actually a slap to the authority of the court. It is contemptuous. It is extremely irresponsible and has no place in a country that is governed by the rule of law. Immediately the court pronounced itself, EPRA should have revised those prices. And I hope that in the fullness of time, there will be full refund to all those who have incurred this price, which they ought not to have incurred, because in normal language, this is what we would term to be an act of unjust enrichment on the part of the government.
All right. And finally, just in about 30 seconds, we have seen several cases that have mentioned that LSK has taken. I mean, during your tenure, there's so many cases that LSK has taken. These are different shift from the previous one, but one of them is the oil one that I forgot to put there. Just in 30 seconds, how do you intend to define your legacy eventually, based on the number of cases that LSK is taking up?
It's not so much a question of the number of cases. It is so much that the Law Society has a mandate to uphold the rule of law and constitutionalism, and to that extent we will always intervene whenever we feel that decisions have been taken that do not comply with the Constitution or with our national legislation. So if there are no decisions that are made, there'll be no cases. But if there are decisions that are made that then contravene the Constitution and the law, there'll be as many cases as those decisions would be.
Eric Theory, LSK President, thank you so much for coming tonight, and definitely we look forward to talking to you about these cases. And I know the most important cases that now we're looking up to is the outcome of this case on the Finance Act 2023, and of course you've gone to court about the strangers in cabinet. Looking forward to see what happens. Asante sana.
Thank you so much for inviting me.
Ahead in our business news tonight, insurance companies